You're welcome back to Law Minstrel. As you know, is a law lecture channel that is bringing you lectures on law principles in simplified format to enable you understand them better and fall in love with law as a concept generally. And I am bringing you this lecture for today. This is a continuation in our series on law of agency. In the last episode, we took what agency is all about, the definition of agency. Today's episode will be focusing on the legal issues that ensue from the definition of agency. In the last episode, we tried to make it plain that the law of agency is simply a legal relationship between a person called the principal and another called the agent who acts on the principal's behalf and binds him in so doing. And we also took note that there is actually no definition that ends all definitions of the law of agency. And so, in defining the law of agency, there are certain legal issues that should be present. And when these issues are present, it will be deemed that your definition is okay in law. We'll be taking a look at these issues that should be present in your definitions, such that you can form your own definition of what agency is all about, but in so doing, you should ensure that these issues are present in your definition. The first issue is that the law of agency is a legal relationship that is recognized in law. It is important that it is a legal relationship that is recognized in law. If it is not recognized in law, or it is not recognized by the law, then the courts will not pronounce it as an agency relationship. When something like a wrong proceeds from that relationship that you are having with someone, then the law will not be able to protect you because that form of relationship that you are having is not recognized in law. The second thing is that the relationship of agency exists between two persons. One of them is called the principal and the other is called the agent. So, agency relationship cannot exist between, and I'm using the word between in all carefulness. If I were writing it down, I'll put it in inverted commas. Law of agency cannot exist between one person. It must exist between two parties. Again, the relationship is born out of an agreement, and this agreement could be expressed or it could be implied. In other words, an express agreement is one that is done obviously and there is no question or confusion to the fact that there was a request and there was an acceptance of that request. That's an express agreement. Then an implied agreement is a direct opposite of an express agreement, and therefore it means that it was not expressly done, but it could be inferred from the action of one of the parties. For instance, I'll give you a very interesting example. There is a couple that I know that the husband says he made a proposal to his wife to marry him. The wife never said yes or no, but he went ahead and did introduction, paid the bride price, did the wedding. The wife has had children for him. Some of these children are graduates, and up to today the wife has not said yes or no to the proposal that he made. But she has said yes because by the acts that followed, you can infer that she said a yes. Otherwise, all of those other transactions that happened would never have happened. And that, to me, is an excellent example of an implied consent. So, an agreement may not be expressed, but by the actions that have ensued between the parties, you will imply that such an agreement actually took place. 4. Within the relationship of agency, one party is usually called the agent, and this party is the one who undertakes to act on behalf of another party in that relationship, called the principal, in relation to other third parties. The 5th issue is that within that relationship, there is another party who is called the principal, and this party necessarily agrees to be bound by the actions taken by the party that is called the agent. This party that is called the agent acts on his behalf in relation to third parties, like we have already said. Now, finally, why it is compulsory that the principal has contractual relationship. It is not compulsory that the agent should equally have contractual relationship. This may sound absurd because it is the agent that is acting, and you want to feel that the agent should have capacity to carry out the acts that he's acting on behalf of his principal, but it is not so. This principle is rooted in the legal principle or maxim that you cannot give what you do not have. Nemo dat quod non habet. If the principal does not have the capacity to do an act, he cannot give the capacity he doesn't have to someone else to enable such a person do that act on his behalf. Conversely, if he doesn't have capacity, what he is giving out is the lack of capacity or the incapacity, which would make whatever the agent does on his behalf to become void, to the extent of the inavailability or non-availability of the capacity from the principal ab initio. I will give an example that will make it very simple, especially for persons of the Christian faith. If a person or a minister in the Christian faith comes here to minister, say a deliverance session, he comes to do that ministration in the name of Jesus Christ. He does not have the power to do that himself, but the power resides in the deity that enables him to carry out the deliverance session. So when he comes, he does not call on his own name, because his own name does not have the power to effect the deliverance he seeks to effect. Therefore, he calls on the name that is his principal. So you see that if the principal lacks that capacity, the deliverance would not happen. And I think that that makes it simpler for you to understand why it is this principal, the sender, that should have the power rather than the person who goes on his behalf. And another good example also lies in the message. So when someone is sending someone on a message, the messenger's authority does not really matter. For instance, a messenger comes here and tells you that His Excellency the Governor of so and so state says you should vacate this place. The messenger who bears that message may even be a toddler. But if it's a toddler that you know actually comes from that governor, you are most likely going to take the instruction. So the capacity is not in the person who is bringing the message, but the capacity emanates from the person who sent it. And that's the same thing in the relationship in the law of agency. The agent may not have that capacity to enter into a contract, but it is compulsory that the principal must have the capacity to enter into the contract that he seeks the agent to enter into on his behalf. And with that, we have come to the end of this episode on the legal issues involved or necessary or pertinent in the definition of the law of agency. Thank you so much for your time. We'd like to urge you to click on the subscription button to enable you to get the ensuing episode on the law of agency. Click our like button as well and give us your feedback in our comment section. Once again, I am M. Nim.